So, as many of you know, one of the prime objectives of the foster care section of the IWGB is to achieve worker status for foster care workers. Now, worker status is similar to employee status, but it's a category of self-employed people that have a number of employment rights because they carry out their work as part of someone else's business. So it's a sort of intermediate category. Now, there's a number of ways in which we're trying to achieve worker status. One is by getting new legislation passed to give workers' rights to foster care workers, and we're doing that through an all-party parliamentary group that the IWGB is running the secretariat for, and we've had over 18 MPs and peers sign up to that all-party parliamentary group to take a look at that issue. And the other way we're doing it is through test case litigation. Now, the problem we have with the test case litigation is there's been a number of cases from as high up as the Court of Appeal of England and Wales saying that foster carers don't have contracts. So that agreement you sign with the local authority that says what you have to do, how you have to do it, how much you're paid, how you're supervised, etc., according to the Court of Appeal, isn't a contract. And that's a problem because to be a worker or an employee, you have to have a contract. So that's been the hurdle we're trying to overcome. We've already won one case, the Johnstons against Glasgow City Council. We got around that by saying that foster care agreement was a contract, and in fact it was a contract of employment. So we already won one case, Glasgow's appealing it, and we have a number of other test cases going on. We have Sarah Anderson's case against Hampshire County Council, we have a case against Kent County Council, and a number of other cases in Scotland arguing that foster carers are actually workers in law and entitled to basic rights. Now, we've just gotten involved in another case, and this is a case of a trade union, the NUPFC, that tried to register as such with the certification officer, which is the government body that regulates trade unions. And the certification officer said they couldn't register because they didn't qualify as being a trade union. And the reason for that is the trade union laws say that to be a trade union, you have to be majority workers. And this government body looked at those cases from the Court of Appeal and said, well, foster carers don't have contracts, they can't be workers. A union that only represents foster carers, therefore, isn't comprised majority workers. Now, this is a problem that doesn't arise for the IWGB because we are a registered union. We have our certificate of independence. We're on the list of trade unions for the certification officer, and we're not majority foster care workers. So we're perfectly entitled to go on representing foster care workers, bringing tribunal claims, etc., because we're not a union that only represents foster care workers. Of course, we have cleaners and security guards, etc., etc. Now, the NUPFC has appealed against this decision of the certification officer, and the case now goes to the Employment Appeal Tribunal. And the Employment Appeal Tribunal is going to come to a very important decision because they're basically being asked to rule on whether foster care workers throughout the UK should be classed as workers and therefore entitled to workers' rights or not. Now, the IWGB has been given permission to intervene in the case. Now, that means even though we're not a party, it wasn't our union that wasn't allowed to be registered. So even though we're not a party, we can make legal arguments. And at first we were given permission just for written arguments, and now we've been given permission going forward to make oral arguments. Now, the main argument the IWGB is going to make is that regardless of whether foster carers have contracts or not, the European Convention on Human Rights requires that we be allowed to form trade unions just for foster care workers. As I said, this doesn't directly involve the IWGB right now because we're not majority foster care workers, but we're arguing that foster care workers should be able to unionize in whatever form they want, whether that's part of a bigger union like in the IWGB or whether it's part of a union that's just for foster care workers like the NUPFC. Now, what we're saying is Article 11 of the European Convention on Human Rights, which is about the right to freedom of assembly and trade union freedom, right to join a trade union to protect one's interests, requires that the government allow foster care workers to form their own trade union whether they have contracts or not. Now, because this Article 11 argument is somewhat new, since we're bringing that argument to the table, in addition to the arguments that the NUPFC is making, both based on the European Convention of Human Rights and on British law. Today, in the Employment Appeal Tribunal, the judge said they were going to postpone the case to give the government an opportunity and the Association of Local Governments an opportunity to intervene in the case as well. So this is an important case. It goes to whether foster care workers are indeed workers. It goes to whether foster carers are entitled in law to form their own trade unions. The government may want to get involved to make arguments, obviously, against us. The case has been listed for a full hearing for 4 days at the end of March and beginning of April. And we're going to be doing everything possible, as we've done up until this time, to get as many legal rights recognized for foster care workers as possible. And that includes basic employment rights and trade union rights.